at that friend's house, you noticed the lights were out, you decided not to waken her up, and you proceeded to drive around for a while. You ended up in the Granger area where you decided to smoke some dope.
Your Honor, excuse me, but if he's going to ask me a question, I will object to the summarization of the entire line of questioning. He's going to ask me.
Well, if I've sufficiently refreshed your memory, say so, and I'll stop. You want to tell us about that testimony?
Do you recall that? Do I recall the testimony?
You apparently do. You just told the court there was lengthy questions and answers about that point.
All I'm saying is that I don't recall the testimony specifically, but I can say that in general that I can associate what you're saying with the trial in Utah.
Okay. Specifically, do you recall telling the court in Utah that you fled from the officer in order to get the smoke out of your car, and that you threw the marijuana out the window during the chase?
Yes.
Now, back to this case. Isn't it a fact that you've done all of the research on this particular motion?
Yes, such as it is. Yes, I have.
Have you found some cases on the point?
I found too many cases.
And the point we're talking about is consent to search, isn't it?
That's one of the points we're talking about.
Are you familiar with what the factual basis would need to be for a consent search to be thrown out?
Yes, I'm familiar with it. I am now. I wasn't then.
That hasn't colored your testimony a bit.
I think you'll find, well, no it hasn't. And I think you'll find, if you review my testimony in the suppression hearing in Utah, that it's essentially the same.
That's all I have, Judge.
And who's that? Do you have anything further, Mr. Clement?
No, sir, I don't.
Any further testimony on the motion?
I feel like I need to call Officer Hayward just briefly, Judge.
All right. Officer Hayward. Sergeant, I guess he is now.
Need to re-swear this witness?
No, sir.
Step out of the witness stand, sir, and be seated.
No, previously sworn, Sergeant. The oath is still applicable. You may proceed, Mr.
Thank you, Judge. Sergeant, are you familiar with the smell, the odor of marijuana?
Yes, sir.
How long have you had some experience in this odor?
I had 3 years, just prior to this date, of alcohol and drug enforcement, drug drivers in the state of Utah.
During the time you were in Mr. Bundy's car on this particular evening, at any time did you smell the odor of marijuana?
No, sir, I did not.
At any point during your search in the car or around the car, trunk, engine, whatever, did you find any substance that resembled marijuana?
No, I did not.
At any time during your chase of Mr. Bundy, did you see anything thrown out of the car?
No, I did not.
That's all I have.
And redirect? Cross, excuse me.
We approach the bench.
Yes, sir. marked his report on your,
We've marked the report. This one. This is,
Just asking if that's the full report, if it's accurate.
Sergeant Hayward, I'm showing you a document listed marked as defendants proposed exhibit A1 identification. I ask you to identify that, please.
It appears to be
Appears to be what?
the same document I have here, full document.
Your incident report of the stop that occurred on August the 16th, 1978.
Yes.
That offered this in the evidence.
be received without objection, out of order.
Okay. That's all I have.
Sergeant Hayward now be excused.
Yes, sir.
That'd be free to do so. Friends have anything further on the motion?
Nothing further, Your Honor.
State have any other rebuttal?
No, sir.
Motion's closed. And gentlemen, I'm going to take argument on both of the motions to suppress. Need a procedure that you want to go by. You may take the state, would argue first. Go ahead.
Motion to suppress what? Is this motion to suppress even yours testimony also?
Yes, sir.
I'm gonna have to gather my troops.
Are you prepared to argue on this one first, then?
Gun, I'm not prepared to argue the law beyond generalities. I have a great deal of case material. As I say, I have not had access to library to streamline it, as it were. I would be willing to make a general argument, but would reserve the right to submit to the court a memorandum of...
All right, I'm going to rule on both of them till in the morning anyway. I want to hear the argument on both of them this afternoon. There's no more hearing testimony. How about Picano and...
Do that during trial if you want to, Judge.
I thought we had reserved that for during the trial. This is all the testimony to be taken on a motion.
Yes, sir. No, sir, we have some statement testimony that you need to hear and some more Williams rule.
Well, we've got some William Rule questions, but they primarily will be not witness testimony, as I understand.
You do have some short testimony.
All right. Well, let's take these two motions to suppress from that order. I'll hear argument on them now, and then we'll...
Judge, will you give me a chance to get Mr. Haggard?
Yes, I think you should, and we're going to proceed now with the argument on the Granger, and Mr. Bundy, you may proceed.
Your Honor, there's a lot of cases in that box, and they all deal with consent search issues.
Yes, sir, I'm sure that there's probably that many more that you've missed.
And I've missed quite a few. We're only dealing with a couple jurisdictions. As I said, I'm going to argue the law broadly because I haven't had an opportunity to complete my research on the status of Florida law, although I'm familiar with the parameters of the consent search issue as they exist here in Florida and those as outlined by the United States Supreme Court and other federal courts.
So we basically set the stage. I'm sure you've read Bustamante.
Yes, sir.
So let's proceed with that, and we'll go from there. You're not going to be far wrong from Florida law.
Well, I think before I refer to the Bustamante case, I think it's important that the court be put in a position of determining whether it's Florida law that applies or the law of the state where the search occurred. And of course I would argue that from the integrity of this court and the integrity of the court of Florida, the conflict should be resolved in the manner of adopting the law of the forum state of Florida to determine whether a consent in the search that we've heard testimony in today was freely, voluntarily, and knowingly given.
Well, you've got more of a basic threshold argument as far as that is concerned. This court would have to take into consideration the rulings of the Supreme Court of Utah, Mr. Bundy, as far as the concept is concerned. And the only collateral attack, or something in the nature of the collateral attack, would be a federal argument. As this court conceives the law, I think the state of Utah has ruled on it, and it is provision of the Constitution that you're well aware of concerning full faith and credit and finality of the arguments as it relates to seizure of the goods under the forum of where they're seized. This court would consider that the only possible collateral approach would be on the basis of some additional federal requirement, maybe not brought to the attention of the Utah court. However, so that the record is patently clear, I'm going to proceed with the concept that both arguments, or all three arguments, are in fact open. And I'm not going to close you out on that. Brevity has never been the keynote of this trial and probably never will be. So I'll hear whatever you have to say.
Well, I think, and I will do my best to acquaint the court with issues that are directly involved in the search, which did not come to the attention, or I would tell the court that these issues did not come to the attention of the Florida Supreme Court, or the Utah Supreme Court. However, I understand that the court has read the Supreme Court opinion, the Utah Supreme Court opinion, and will simply direct the court's attention to the findings of Chief Justice Ellett. And Chief Justice Ellett did not find that the search ruled on by the trial court was legal. The legal finding of Chief Justice Ellett in State v. Bundy was that there was evidence sufficient to justify the judgment of the court. It does not speak to the standards of law in Utah or anywhere else as applied to search and seizure, and the search and seizure issue involved in the Utah case. I think what we have here is simply a badly written opinion, and one which is self-evident, relies on virtually no case law and a very highly complicated appeal. And so I will say only that I don't believe reading of the Supreme Court opinion is dispositive or in any way persuasive in determining the legality or illegality of the search that occurred, and it's the subject of this motion. And let me go to the Bustamante case because it's so often referred to and because it's so important in consent search cases. And I think that this court must first recognize that in the Bustamante case, the United States Supreme Court narrowly decided the issues before it and concluded that its ruling on whether an advisement was necessary
Pappa och jag har pratat om en sak. Vi är lite oroliga för dig.
Det handlar om skärmen.
Where is the lady?
Pardon?
Where is the lady?
Where's Mrs. Mary?
She's right across the hall.
Does she have photographs with her or clippings
I
with her?
don't know. You'll have to ask her. She might have them in her purse.
You wanna let this young lady step down from the stand and bring her over? If they're of some benefit to us, if you can get them for us, Mr. Simpson, that's